Here, here, here. The Honorable Christine here. The Honorable Christopher P.H. and presiding the Honorable Historical. All person that is out there. Welcome. I note that we came out, I think, 2 minutes early. And as I tell my kids, as they're struggling to get out the house, if you're not early, you're late. So welcome to the Michigan Court of Appeals. I'm joined this morning with Judge Garrett and Judge Yates. And we have, I believe, a full morning. So why don't we get right to it? I believe the first case on our docket is actually number 2. The first case we're going to hear tomorrow. So we're going to go to number 2 on this morning's call, docket number 372187, People v. Boglarski. And I guess I should have said before I even called that case that if there's a minor involved, let's be sure to either refer to the person as a minor or the initials. And if you have a cell phone, you can put it on vibrate. All right. I believe Ms. Sharon. Good morning.
Good morning, Your Honor. Can I just ask if you can hear and see me okay?
We can.
Okay. Thank you, Your Honor. Alona Sharon on behalf of Mr. Boglarski, Your Honor. May it please this honorable court. Your Honor, I did double check one last time this morning to see if any pleadings had been filed by the prosecutor in this case, and it appears that nothing has been filed. So I don't really have much to reply to. I do just want to address a couple points, if that's okay with the court. As it relates to the scoring error of OV10, I would simply rely on my brief. I don't think I need to revisit that issue. In terms of Mr. Boglarski's entitlement to resentencing, I think, number one, the significant reduction in his guideline range following the trial court motion to correct an invalid sentence entitles him to resentencing under Francisco. The trial court relied in part on the case of People versus Mucci. I hope I'm pronouncing that correctly. And I really think that this court needs to revisit that decision. And in a prior opinion in one of my cases, People versus Meekoff, I think it was Judge Gleischer who outwardly questioned the vitality of the Mucci decision, given that Francisco was decided 3 years after Mucci. And in Mr. Boglarski's case, we have a significant reduction in his guideline range, in the correct guideline range, following the trial court motion. And I think the direction and instruction in Francisco is unambiguous, that Mr. Boglarski has a due process right to be sentenced on accurate information. And where there is such a significant reduction in the guideline range, then a resentencing is absolutely required.
Sharon, can I stop you for a second? You make a very good point about the fact that the guideline range came way down when it was adjusted. But it seems to me that the driving force behind the 20-year minimum sentence was the fact that there were CSC1 charges against a 12-year-old too. And that would have been a mandatory 25 years, right?
Well, he wasn't convicted of that, Your Honor.
I get that. I understand that, right? The count of conviction involves a 13-year-old. And so obviously the 25-year mandatory minimum doesn't apply, but it certainly would have been the case had he been convicted of the 12-year-old, the CSC1 against the 12-year-old, it would have been a 25-year mandatory minimum, right?
That is correct. But I also think, Your Honor, and actually looking at the transcript when I was reviewing the case for argument today, first of all, the court really doesn't give a ton of reasons for the upward departure, but one of the reasons that the court did say for the upward departure that was a big factor for the sentencing court was that Mr. Boglarski's total OV score was 145 points. And because the top grid, right, maxes out at 100 points, that he therefore had 45 points for that were not accounted for in the guideline range. Of course, that fact isn't true anymore, right? Because his corrected OV score is a total of 60 points. I would note if the court grants the challenge to OV 10, his total OV score would become 55 and the guideline range would be further reduced to 42 to 70. But so not only do you have the fact that his guideline range is significantly reduced, but also one of her strongest reasons for the upward departure is no longer legally or factually accurate, right? His OV score is no longer 145. It's all the way down to 60 due to the objections that were made. So I think, and even just going further, Judge Yates, is first of all, I would argue that she doesn't really give very many explicit reasons for the departure. She gives no explanation as to the extent of the departure, but also, even if she had, those reasons for the extent of her departure, right, are no longer sufficient because the extent of the departure is so much greater now due to the reduction of the correctly calculated guideline range.
So that raises an interesting question that I had in terms of, when we look at the proportionality of the sentence, we look at the seriousness of the matter, not necessarily whether it adheres to the guidelines or not. There's case law that says that. But then there's also other case law that says that a reviewing court has to look at not just whether there were sufficient reasons given for a departure, but also for the extent of the departure. And I'm trying to figure out, as a reviewing court, how do we square those two principles? One, that the guidelines, when we look at the proportionality, we look at the seriousness of the matter, not whether it adheres to the guidelines on the one hand, and on the other hand, we've been told by our Supreme Court, we must review the fact of a departure as well as the extent of that departure. How do we square those two principles, in your opinion?
Okay. So, Your Honor, if I can just address one thing that you said before answering your question, if that's okay. So Your Honor said that the sentence should reflect the seriousness of the matter and not necessarily the guidelines. I would very respectfully disagree because I think the case law very clearly states that the guidelines, right, each offense has a class and the guidelines are calculated. And so that guideline range does in fact reflect the seriousness of the offense, right? Because you're.
I want to make clear, I'm not just, this isn't the law according to Brock. I'm quoting from People v. Mason, a recent Michigan Court of Appeals decision, quote, "When reviewing a sentence that constitutes a departure from the recommended minimum guidelines range, the key test is whether the sentence is proportionate to the seriousness of the matter, not whether it departs from or adheres to the guidelines recommended range." Close quote.
Right. And so just the comment that I'm trying to make is that there is case law, and I do believe it's in part in one of the Steenhouse decisions, although there's about 27 of them, that proportionality for the offense is baked into the guidelines for that offense. And I believe that case law is cited in the brief. But to answer the question that you put before me, assuming I can remember at this point, is that, right, I do think the court is right, that there's essentially a two-part analysis. And one is that, okay, do the facts of this case warrant a departure, right? Is it more serious than your typical, CSC 1 or armed robbery, whatever? And then does the trial court make a sufficient explanation about why this particular sentence, which is outside of the guidelines, why this extent is more proportionate than a sentence that is within the guidelines? And I think it's just a two-part record that the court has to make. One, why is an upward departure warranted? And then why is X months the appropriate proportionate sentence for the defendant? But I think in Mr. Baglarski's case, where a significant factor for the trial court was the 45 unaccounted points, right? That reason just doesn't hold water anymore. I also just want to note, Your Honor, that the case law is very clear that a sentence should always be rooted in the guidelines, right? That is the first place that the court should look when imposing sentence. It should consider the guidelines, even though after Lockridge, they're not mandatory. And that leads me to my last request and the fourth issue that was in the brief. I think that given statements made by the trial court at the time of the motion hearing on the motion to correct an invalid sentence, that it is appropriate to remand this matter back for resentencing in front of a different judge. I believe it was Judge Clapp made very clear that the guidelines were wholly irrelevant to her, that she would not consider them in imposing a sentence, and that she had already made up her mind that if she went through the, essentially the show of a resentencing,
I believe her statements were, we can go through the motions.
Yes, thank you, Judge. We can go through the motions, but I'm going to impose the same sentence again. So number one, a more explicit bias I really can't think of. It is an outward disregard for the applicable case law, but also, Your Honor, under People v. Rosenberg, if Mr. Beglarski, if this court does remand for resentencing, it's appropriate for the court to consider his conduct since he's been incarcerated, because that can be and should be considered by the court as evidence of rehabilitation. It can also be considered against him if he's gotten a ton of tickets or has other problems while incarcerated. But Judge Clapp's statements make very clear that she is not interested in that, and she's not going to consider anything that is appropriately before the court other than she imposed 20 years on the minimum the first time, and that's what she's going to do the second time around. And those statements made by the judge make it impossible for Mr. Beglarski to get a fair resentencing should this court remand for resentencing, which, of course, I think it should.
No questions.
No, thank you.
I think that's it. And so we appreciate your time, and that matter will be submitted.
Thank you, Your Honor. Have a good day.
Thank you. You too. Calling the third matter on our docket number 373995, in re attorney fees of Roman. And I apologize for this last name. Starts with a T.
Tishkevich.
There you go. Thank you.
Good morning, Your Honors.
Good morning.
Roman Tishkevich on behalf of myself. I just have a couple updates for this case, and I think the brief is self-explanatory and will speak for itself. This court, the Court of Appeals, has granted Mr. Vanden Bosch's application for leave to appeal pretty quickly. It granted it, and that's the underlying case in this that I'm working on in 42 days, and that case is currently pending before this court. The parties have already filed briefs, answers and responses in that. The next thing is the circuit court lifted the stay. It imposed a stay on any future attorney fees in this case, and it lifted the stay for payments. And it has paid the majority of 3 subsequent vouchers.
And it's approved those and paid them, correct?
It has.
Okay.
It has approved and paid. So I'm here on the 4th voucher, and it's paid 5, 6, and 7.
Okay, you answered my question. Thank you. Because there were 3 that got paid, but that was right around 15 hours worth of work.
Right.
Then the bigger one, the 27 plus hours, didn't get paid. And what you're saying is there were 3 after that that got paid. What was the aggregate amount that was paid on 5, 6, and 7?
On 5, 6, and 7, the aggregate amount was $8,702.
How many hours were those?
16 cents.
Roughly.
I think those were about 40, I believe, hours or 30.
In the aggregate.
In the aggregate,
Okay.
because those went for the application for leave, for the brief on appeal. And I think the only one that's pending right now is for the reply brief.
Gotcha.
That we had to file for that. So we're pending oral arguments on that case, on Mr. Vanden Bosch's case. And finally, the Appellate Defender Commission adopted a new attorney fee and a reimbursement policy in March. So the Attorney Defender Commission took away the presumptive reasonable hours. So we no longer have presumptive reasonable hours, which I think is where the circuit courts get tripped up on. We try to explain it to them. It's not a cap. It's presumptive up to this. And then after that, you look at it reasonable or reasonable hours. And so there's no longer presumptive. And they have added a definition of reasonableness has been added. So I think that will help as well. But beyond that, if the court has any questions on my brief or.
We don't. We appreciate you coming today and in updating the court on all those matters. It's helpful and puts this matter in the proper context.
Thank you.
Thank
Your
you.
Honor. Take care.
That matter is submitted. Calling the fourth matter, docket number 370181, Johnson v. Johnson. I believe Ms. Schmidt is appearing remotely.
Morning, Your Honors.
Morning.
You're just cranking through them this morning.
You know, it's Grand Rapids. We do things efficiently over here. At least that's what I've been told.
Well, I'll try and keep it going. Lisa Schmidt appearing on behalf of Doris Johnson, appellant in this matter. Since I am unopposed and I believe the legal error in this case is very transparent and easily stated, I'll be very brief. A consent judgment of separate maintenance is an enforceable contract that binds the parties, even in the subsequent divorce, and the trial court committed clear error by refusing to enforce it and explicitly stating multiple times that it was not binding.
So what about, not to cut you off, but what about Engelman?
Engelman was a decision that predated the most recent amendment regarding the separate maintenance. In fact, it did not involve a separate maintenance. It involved a divorce of bed and board.
Yeah, that was a new one. I hadn't heard that one before. I can understand where they came up with that, but but you know, I understand that the law is your point that the law has changed since then, and therefore we shouldn't feel bound to follow Engelman, even though it is a pre-November 1st, 1990 case.
I believe both that Engelman no longer applies because of statute, and as you said, it's older than 1990. But also precedent has evolved since then, because Staples says that the parties can clearly and unmistakably agree to a non-modifiable spousal support, and that agreement is enforceable. Now here, the language is pretty clear. It's alimony and gross, which is non-modifiable anyway. It was an alternative award in lieu of the pension. If a quadro wasn't going to work, then he was going to pay it to her directly. So it's very clearly alimony and gross. But if the court were to read that as it being spousal support rather than alimony and gross, it still contains that non-modifiable language as required by Staple. Staple is more recent than Engelman. Staple controls.
Ms. Schmidt, I'm sorry.
Well, I was just gonna say, your client agreed to modify the property distribution. I mean, she argued for a different property distribution than what the consent judgment had permitted.
In what way, Your Honor?
She agreed to have the marital home in exchange for forgoing the $80,095.69 equalization payment.
I understand what you're saying now. I apologize. I wasn't following you there. So I would argue that she was saying that would be a satisfaction of everything that was owed, would be just to do it in that way. And that, I would argue, is because of the difficulty in enforcing all of the terms of the judgment against this gentleman who simply refused to sign anything put in front of him.
And that may be the case, but your client did argue below or take a position below that the trial court could modify the property distribution. So all I'm suggesting is that the property distribution component, you know, you might be stuck with what they have, but on the alimony and the other components, I think you have a fairly strong argument.
I would say I do agree that trial counsel could have articulated that more clearly, that it was a matter of a way to enforce the terms of the property judgment. I do think that, I mean, my request on remand is that a judgment of divorce be entered that is in compliance with the consent judgment of separate maintenance. So I agree with you that we can't pick and choose, that if we're going to say it's enforceable, then it's enforceable.
Well, let me ask you this though, because a consent judgment, whether it's of divorce or separate maintenance, is a contract. And generally, one party can't unilaterally modify a contract. And I agree with you. But if the parties jointly agree to modify the contract, Michigan law is very clear that you can modify a contract, as Judge Schwartzel described, seems to have happened here, with some components, but not all of them. Why is that analysis not accurate?
Well, they certainly could have agreed on specific terms to modify. Nobody agreed on how they were going to modify. Even if we're going to take trial counsel's inartful statement to say that we also want to modify the property division, there was no written agreement on what that modification was. There was not even an agreement that they wanted to throw out the property distribution and start fresh. It was instead this piecemeal, like this person wants to change this part and this person wants to change that part. And that's not a clear written amendment to an agreement, which is what a contract requires for it to be amended.
Well, but you're also stuck in the position, or you might have to deal with the matter of waiver, because if your client below agreed that the property distribution in the consent judgment could be modified, you can't come now on appeal and say, wait a minute, it should not have been modified. I mean, if it was argued below that the property distribution could be modified, you do have an issue of waiver here. This is just an ordinary civil matter.
Now, again, I disagree that it was arguing that it would be modified. I believe that if you look at the transcript, it's clear that they were saying that the turning over of that property would be in satisfaction of the contract. So I believe that that is not necessarily a modification. It is an enforcement. However, even if that is the case and the court wants to look at this as the parties had agreed to modify the property distribution, then we have the problem of what happened at the end of the trial, which is that when the trial court decided it was going to modify the property, trial counsel said, well, we didn't actually litigate those issues because we didn't know that they were in front of the court. So we need to reopen, we need a new trial on the issues of property. And the court said, no, I'm going to make my mind up based on what you wrote 10 years ago. So the court both simultaneously enforced and did not enforce the settlement agreement. And I think if the court is going to say that the parties agreed that they were going to modify the property division, and they were going to reopen the issue of property division, then we actually need a trial on property division, because that's not what happened here.
No, thank you.
Thank you.
Anything else that you want to let us know?
No, I was prepared to be very short, Your Honor.
All right. All right. We appreciate your participation this morning. It's been helpful, and we will get an opinion out hopefully soon. Okay.
Great. Thank you, Your Honor.
Thank you. That matter is submitted. Calling the fifth matter for this morning, docket number 368740, in re petition of Lake County Treasurer for foreclosure.
Good morning, Donald Visser on behalf of the appellant. I'd like to reserve 5 minutes, if I may, for rebuttal.
Okay.
Just place my notes here. That's probably not good, is it? This is the first time, at least I've been in front of you, Judge Horschel, since N. Ray Muskegon. I'd like to start at the beginning of that and see if we can't do a redo.
Well, if you want to talk about redos, why don't we start here, Mr. Visser? Because it seems to me that you were in front of Judge Godola, Judge Rick, and me in July, and you made all the same arguments you're making here today, and we flatly rejected them in an unpublished opinion, to be sure. But
Well, you did. You
I
felt
tried to
cons-
line up
you
that,
felt
that
const-
opinion with the brief and it looks like it's all the same.
You felt constrained. Well, and that brief was initially written very, very early.
Right,
And
absolutely.
my reply was a little bit later.
Yep.
With all due respect to Judge Schwartzel, I still disagree with the decision in Ray Muskegon, but
Right.
let me hone in on why I don't think it's binding in this point. And Judge Schwartzel will have a much better insight because I believe you wrote the opinion and we'll know what you left out and what you did. What I see is Ray Muskegon carved out two exceptions which were not described. And I want to make sure that I make clear to this panel that I recognize Ray Muskegon as binding on the issues that it decided. But footnote 1 indicates that it did not look at the notice provisions that were given and assumed that based upon comments made at the trial court that they were adequate. Subsequent decisions have made that whole issue a little bit clearer of why that's important. And the second exception that was not decided was the impact of Article 2, Article 10, Section 2, which is Michigan's takings clause. That's on page 10 of the Ray Muskegon decision. And as a result, we come up with a little bit, I think, different scenario where we are today. For instance, we've had in the Sixth Circuit, we've had the Bowles versus Abreu decision, which looking at Michigan law, making it very clear that we're looking at two separate properties. The personal property, which is the surplus proceeds, and the foreclosure of the real property, which is really what the notices address.
But can I stop you there? Because I went right to it, the July opinion in Kalkaska Treasure. There's a whole discussion about the notices. You made every challenge to the notice you possibly could, and we rejected all of them. Now, it's an unpublished opinion, but you argued here that 2020 PA 256 violates procedural due process because it does not require 1, personal notice, 2, notices that inform all equity owners that petitioner will confiscate their proceeds, 3, notices that specifically identify the property to be taken, and 4, a hearing before petitioner confiscates the respondent's remaining proceeds. Are those the same arguments you're making today?
Well, the arguments I'm making really follow in Ray Kent County, which is a subsequently published decision.
Right.
I cited it in my supplemental authority, where it says very clearly that the notice, if the notice does not comply as to the surplus proceeds, not the underlying, and that follows where Raffaelli came from. Raffaelli says there's two different things.
Right, absolutely.
And so what you have to, and we're saying in this instance that the notice, actual notice, does not comply sufficiently to do due process. First of all, it does not tell you, for instance, if you look at a notice, and the record is incomplete here. So in Ray Kent County, what I call Broughton versus Kent County, sent the case back for an evidentiary hearing on the notices. Right. But the notices do not say that we're taking your surplus proceeds. It doesn't say what the impact of failure to.
But don't the notices say something to the effect of, if you want to claim any surplus proceeds, you must submit this form by X date?
It says you may. It does not say what the consequences of that are. So you have most of the notices that go out at the top say you have lost all of your equity, Judge. All of your equity. That's in bold. Later on, it says you may file. Well, okay, if I file it, I can follow this procedure. But if it doesn't tell me that you're going to lose your equity, then you have a failure of due process there because you weren't notified of the extent of that. And now look again at, as we get into some other aspects of due process there and so forth, is you with the two different properties. One, if you look at the jurisdiction, you have NREM jurisdiction for the statutory foreclosure of real estate. How do you get NREM jurisdiction of the surplus proceeds. How do you get past then Article 10, Section 2 of the Michigan Takings Clause, which says that Michigan can't take anything? Eventually, it's that property, government eventually is going to claim ownership, I assume. Section 78T never transfers ownership. So when does that ownership transfer? Isn't that a taking?
But that seems to suggest that you'd prefer to have a direct action under the takings clause, whether that's Bowserman or some other mechanism, right? Than to proceed under the 78T method.
Well, I think Bowserman should be there. And I think the real conflict here is not whether you can proceed under 78T, but the modified 78L, which says that it's exclusive as to all causes of action. And I don't think you can reconcile that, for instance, with the recent decision of Williams versus Reed out of the United States Supreme Court, which was earlier this year, that says that if Congress gives a right under 1983, states are powerless under the preemption to preclude that. So that's one of the nuances here, is that how in the world can you cut off those claims that would exist under the federal Constitution?
Well, it sounds like that issue is working its way to the U.S. Supreme Court now. I mean, I was at a conference where a judge from the Eighth Circuit gave a summary of the U.S. Supreme Court term. And he said, I have this very issue in front of me on the Eighth Circuit right now. My sense of it is sooner or later, the U.S. Supreme Court's going to have to decide that. But until they decide that, we're bound by the contrary decisions from this court, aren't we?
Well, I don't think in Ray King County is contrary. I think it supports my position. Nor do I think Cully versus Marshall is contrary, which is the United States Supreme Court, which is issued post in Ray Muskegon, which says you can't have a forfeiture without a hearing after the forfeiture. Now, when you start talking about transfers of title, our court hasn't wrestled with that issue yet, because 78T does not address ownership. Raffaelli addresses ownership. We know where ownership is. Tell me, when does the state or the foreclosing governmental unit acquire ownership? When it does, that's a taking. We know darn well that the transfer of title is a taking. So as soon as MCL 211-87B1 says that the FGU has no ownership interest in the property. 78T doesn't transfer ownership. So when does that occur? And I'll tell you, at that very moment when you say that it occurs, you now have a taking, because you have now transferred an aspect, the fee, to that personal property, the ownership.
But what's your theory about how that compensable taking should be remedied? A separate action? A direct action under the takings clause of the Michigan Constitution or the federal Constitution, or both?
That's a rough part of this, because again, 78L says that the new for post Raffaelli says it's exclusive.
You're almost suggesting that we hold it against the legislature for coming up with a detailed mechanism for obtaining these surplus, where in other types of takings, we don't really have anything. You just have to, file a lawsuit under our general provisions. Here, the legislature actually went through the work of setting up a very detailed, a very orderly mechanism. And I think you're saying we should hold it against the legislature for even doing that.
I don't think I'm saying that at all, Your Honor.
Okay.
Because what I'm saying is the mechanism that's instilled here is totally, in my mind, unconscionable.
Well,
Because you got to.
so that's not holding it against the legislature, saying that it's an unconscionable mechanism?
You said a process for doing a process. For this process, yes.
Okay.
Because this process says you have to do so on July 1 before the property even exists.
So, but that was also something that we discussed in Ray Muskegon.
Oh.
You're holding it against the government for holding a hearing or providing process pre-deprivation. That in most circumstances, that's the best kind of notice you can get, or process you can get, is before the government action occurs, we're going to give you an opportunity to come in and make your case, make your claim. You're suggesting that pre-deprivation process is actually deficient here, and it should be instead post deprivation.
That was addressed in Cully versus Marshall, because there's a conflict there, I think, between the Sixth and the 10th Circuit or so regarding pre and post hearing. And Michigan and Sixth Circuit said there had to be a pre-hearing beforehand. And the United States Supreme Court cleared that all up and said, no, there must be a post hearing. Now, whether we like it or not, I think that's binding. And I think as a consequence, in essence, overrules where we were in Muskegon, whether we like it or not, whether it's good or not, that's what it says you must do. If you have a forfeiture, you must do so afterward. I think the problem that I see, particularly, Your Honor, with the notice, if it had been done differently, for instance, let's say after the sale, and you have property that you can identify that you're supposed to collect, then if you have a procedure and so forth. But here you have just, when we were down in the Eastern District in the federal court, the judge asked one of the other attorneys, well, what is that between the March 31 and the date surplus is created? What is that? And the response, well, it's a nothing. Well, you're giving notice about a nothing? That's really what it is. You don't have something that you're giving notice as. You're not proceeding as to anything. It's an anticipation. And even the notice that you get where they say you may file this notice is that if there's any proceeds, and there may or may not be a sale. So
Are you aware of claimants across the state who have actually successfully received surpluses by following Section 78?
Yes, Your Honor, very, very aware, because our office sends out letters, and it's surprising how many people had no idea what in the world that notice meant until they got our letter and said, you're going to lose all your rights if you don't file anything. So we submit a whole lot. But I can tell you, if you want to look at the reply brief that was recently filed in the U.S. Supreme Court, a case called Ketter versus, I don't know which county, there's statistics there as to how many, the pittance of people that are actually able, the total amount of people that are actually able to collect funds out of this. It's a very, very small percentage.
But that's not Michigan specific. You're talking about these statutory schemes all over the country.
No, it's Michigan specific.
Oh, okay. Okay. I didn't realize
And
that.
is that a statistic based on just the gross number of people who receive surplus, or of the surpluses generated, the number who actually receive those?
Of the surplus. I'd be happy to send the supplemental brief. I just read it last night. I'm sorry I didn't take it with me, but the reply brief, and by the way, that's set for conference, I think, on the 29th of this month at the United States Supreme Court, along with In re Muskegon. They're both up for conference on that day. So that's really where I still have real problems, not so much where the court came within the issues, but in re Muskegon, but with the excluding the actual consideration of the notice. That's a huge thing. What does it tell these people? Does it really tell them you're going to lose? I have some, you kind of answered in Muskegon before my theoretical problem with the fact that there's no surplus yet. There's nothing to really address. Can you start foreclosing or forfeiting something before it actually exists? That's conceptually and intellectually difficult for me to comprehend. So, but
you have no quarrel with the fact that the foreclosure has to take place to collect what's due in outstanding taxes, right? It's just what happens in the wake of that you're upset about.
And that's where Raffaelli made the distinction too.
Yeah.
The same argument was made in Raffaelli that certainly the foreclosure statute to pay the government what the government is owed is not an issue. It's only that subsequent taking of the real property. And in Michigan, that's a real problem because, there's been a couple of our decisions who have looked to Nelson versus New York. Well, Nelson, I can tell you one thing that's guaranteed. Nelson versus New York would never have gotten to the United States Supreme Court if New York had Michigan's Constitution. Because Michigan's takings clause preconditions the ability of government to take upon first making payment, whereas New York's is much like the Fifth Amendment, does not control government taking, but instead says if the government exercises its ability to take, then you must pay just compensation. So when I've appeared before and have continued.
Is there, you have to forgive me, I don't recall this from Muskegon. Is there Michigan case law that says that we read the Michigan takings clause and the federal takings clause coterminously?
No, in Ray Muskegon, that's what was done because it was argued there or asserted that I did not raise specific issues as to the Michigan's taking clause and distinguish it. Raffaelli itself does not discuss the differences, but acknowledges the differences. And Raffaelli says that Michigan's takings clause gives more protection than the federal, and then it goes on without discussing in great detail what those things are. So
Okay.
it's I have not found any cases that shut down my concerns at all, nor do I have any that therefore support them either and say it's just acknowledged that it's there's a couple other cases too that acknowledge the greater protections, but then we almost everybody ends up going with the traditional analysis under the Fifth Amendment because there's so many cases out there that address that. So that's really where my problem. I still continue to fight with the result of In re Muskegon because there's these two issues out there that really were not addressed, and I think subsequent decisions have really made that In re Muskegon really questionable as far as this application when you throw in both of those elements.
Okay. Thank you.
Good morning to the panel. Douglas Curlew on behalf of the treasurer in the county. It's
You
difficult to
two,
know.
you and Mr. Visser have seen a lot of each other in the last
We
year.
have not, yeah, and we write even more briefs back and forth than we see each other in the court.
So what about the sufficiency of the notice here?
Well, the situation with the notice is what this court said in the Kent County case, and that's the new wedge that Mr. Visser has been using, is that you have to have constitutionally adequate notice. And what we have here in this case, as we can see, and as I quote in the brief, and as we have, the notices say specifically, if you are to make a claim, you must, and that's the words that used, for your excess or remaining proceeds, you must, and then in the.
You must what?
Give this entire discourse on how you have to file your Form 78, your Form 5743, that you have to file it with the treasurer. You can get a copy of the form on the state website, blah, blah, blah. It's all laid out in detail, and you must do it to claim your remaining proceeds. Otherwise, obviously, you're not going to get any money. Must is must. I don't know what else you could be to be more explicit than that.
I think Mr. Visser would say that there should be a sentence. Yeah, I'm sure Mr. Visser would say quite a few things must be added, but he would at least say that something along the lines of, if you do not submit this form in a timely fashion, completed in a proper way, then you forfeit any right to any surplus.
And it wouldn't matter what language was chosen. They would always say, well, we should have said this word or that word or added this sentence or that sentence.
Well, I mean, but that's
The fact
true,
is-
but hold on. Can you address why you don't think the form needs that additional explicit statement about what happens if you don't do this?
It says if you want to claim, you must. Obviously, if you don't do what is a must, you can't claim, you're not going to get anything. That's pretty apparent from what it says. I mean, like I said, I don't know what else you could say that would make it any more explicit than that. And that was on both the forms, both the payment deadline form and the notice of foreclosure form, both of which were sent. and have not been denied having been sent and received. I want to talk about a couple of the points that were made because, as the court knows, a notice of supplemental authority was sent at the very last minute on
Before
August
you do that
18th.
though, is there anything else you want to say with regard to notice in terms of the adequacy in light of the Kent County case, decision that came out?
Well, the Kent County case made clear, it quoted the Supreme Court, the treasurer for Wayne County case, that as long as the notice is constitutionally adequate, whether or not every detail of the statute was followed is irrelevant. I think in this case, we've had complete compliance and complete adequate notice of what the details of it were.
What was the matter remanded in the Kent County case?
Well, I don't know that they ever had there was no indication that they ever had copies of the notices in that case on the record before the court at the time.
So there was a factual question regarding whether notice was sent out.
That seemed to be what it was sent
And
back
in this
for.
case, is the record, in your opinion, clear that this particular notice was sent and received?
The notices are in the appendix that the appellants themselves presented.
So that distinguishes this case from the Kent
I
County.
think it very much distinguishes this case from
Okay.
the Kent County case.
Thank you.
As far as a couple of the additional things that were made, there was a statement about it doesn't tell you what the extent of the loss would be, and he used the word equity. Of course, that's the word that's constantly used in these cases, but that's not what's lost. What's lost is the remaining proceeds, and the notice itself uses the words remaining proceeds are what you must file that form to collect. So the extent of the loss that may be incurred is made clear in the notice. As far as the situation he's talking about, when does ownership of the surplus proceeds transfer? Well, I would point out my discussion in the brief about the comparison to the income tax system. When does your tax refund ownership transfer? I mean, you owe me, the government can't collect more from me in my income tax than I owe. Yet I assure you the state of Michigan does that every year, as does the federal government, and I always put in for a refund. But if I don't put in for the refund, I don't get the money back. I have to take the initiative to file a far more complicated form than 5743 to get my refund back from the federal government and from the state of Michigan in my 1040 and all the attachments that go with it. Yet there's never a debate that the government can keep it if I don't file my refund forms. That's just what happens. There's nothing unconstitutional about that. It's just I didn't do what I needed to do to make my claim. A number of cases were cited in the very belated supplemental authority was submitted, and a couple of them were discussed here or mentioned here today. None of them really apply.
Before you get to that,
Sure.
does Raffaele refer to the transfer of title with regard to the surplus? Because transfer of title doesn't even make sense, in my opinion, when it comes to monies. I don't want to paint too broad of a brush, but it makes a lot of sense when you're talking about real property, like
Right.
actual real property. But in terms of, the surplus proceeds that might come into existence at some point, there's an interest in that, but it doesn't, there's no title that transfers in the way that we speak of in real property terms.
Raffaele never used that term as far as in connection with the surplus proceeds that I can recall, and I've read it quite a few times. As far as the additional cases that were cited, Bowles is discussed. He mentioned it again today for the principle that the surplus proceeds are distinct from the real property. That's not in dispute. I mean, we recognize as the county and in the notices that remaining proceeds are different than what the foreclosed real property was. So that's just not even an issue. I find it odd that the Bowles case is constantly cited for anything. The Bowles case was about whether class certification was proper under Federal Rule 23, and anything else the court discussed in that case was actually dictum. So I don't see that Bowles has any application to anything at all. As far as the Cully case, Cully versus Marshall, Supreme Court decision 2025, it just reiterates the point that if there is going to be a forfeiture, there has to be a hearing. Well, if we want to call this a forfeiture, and I should point out that the Michigan Supreme Court made very clear that tax foreclosure was not a forfeiture in that sense. That was how they opened the Raffaelli opinion. And the federal Sixth Circuit has agreed in its Freed opinion, Freed versus Thomas, 81 F 4th, 566, I believe, or 655. Cully dealt with a situation where you had to have a timely hearing. Well, you would have a timely hearing if you got your Form 5743 in. There's a judicial hearing then, 78T Section 9, where we decide who has the most priority and who's entitled to the surplus proceeds. I make the argument a bit in my brief. I don't think I made it as elaborately as in some of the briefs I've done, that the Supreme Court said in Raffaelli that any type of property interest from that bundle of sticks could deserve compensation in the tax foreclosure context. It's not just the taxpayer. In fact, the taxpayer may be a lessor and not even have a right to surplus proceeds on that interest at all. You've got mortgage holders, lien holders, you've got the fee owner, you've got a whole host of other interests that could be in a property. That's why we have this 78 hearing, so that everybody who has a potential property interest giving them some measure of the surplus proceeds can file their claim, and you can have the hearing where you would then decide who has the claim, who has a valid claim, who has the priority, who gets how much, how would it be divided. That's the whole point. You get the hearing. But if you don't ever invoke the procedures, you don't get a hearing. But that's the fault of the claimant, not the fault of the statutory system. Williams versus Reed was mentioned. That was a situation where you had workers' compensation claimants who made their claim, initiated the proceedings, and what they wanted to do was file a federal claim, due process, saying the state's dragging its feet and it's never going to get around to paying us our workers' compensation benefits. But here we have the different situation where they never even invoked the process. If you don't invoke the process, you can't claim it was delayed. So again, the Williams versus Reed case doesn't apply at all either. Let me see if there's any other cases they cited in that notice that I haven't.
Kent County's the only other one, and we've talked about that quite a bit.
Right, we
already.
talked about Kent County.
Right.
So the
Yeah,
Cullen
there are
Marshall
4
Bowles
cases
and
cited in the letter, and or whatever you call it,
okay.
and we've now discussed them all.
Other than that, I have really nothing to add. I think the brief went through and knocked down all the arguments that were actually made in the brief by the appellants. I wanted to be sure I hit on the things that were added in their supplemental authority and to address certainly the Kent County case. If the court has any additional questions, I can respond to those. No. The only other thing I would just add is to clarify what was addressed for a moment with Mr. Visser is the conference which will be addressing the Muskegon case by the U.S. Supreme Court petition. That is on September 29th. The so-called long conference that opens the term. There's also a Manistee case out of Michigan. I'm not familiar with that particular case or what the issues were in that one that's being heard at the same time. And another case that I have, Pung versus Isabella County, where the issue in that case is whether you can say the Fifth Amendment entitles you to more than surplus proceeds. That is, you can get the fair market value of the property, even though that's not what the government got. So all 3 of those I know are being heard at the long conference on September 29th.
But yeah, getting a grant is like getting Willy Wonka's golden ticket. I mean,
Yeah, pretty much.
good luck with
yes, it
that.
is.
Right. I'm not saying that they won't eventually resolve some of these issues. There's no doubt, for example, that whether you can use the statutory scheme as the exclusive method for recovering your surplus proceeds will wind up in the Supreme Court. I'm sure they're going to decide that
Yeah,
sooner or later.
to me, I think Tyler answers that question and says the procedures are okay, but
The law's good for you now.
Yeah.
You don't have to worry about that unless and until the Supreme Court grants cert.
if there's nothing more, I'll sit.
Thank you.
Thank you.
Mr. Visser, you have a few minutes left.
I speak quickly without tripping over my own tongue. The income tax example, I think there's a red herring. There's no ownership issues involved there. There's nothing that was taken involuntarily according to government eminent domain proceedings and so forth. It doesn't also involve any application of Michigan's takings clause because it's a federal issue there. transfer of title or transfer of ownership, I would make those the equivalent. Title would be a written document ownership. And Raffaelli does address it, makes it very, very clear that the ownership of the surplus proceeds belongs in the individual who previously owned the real estate. Cully versus Marshall, I think there's a great deal more there than what's admitted to. It does say afterwards for forfeiture, you must, well, it doesn't say anything about waivers or whatever else. It says you must have a hearing after the foreclosure, a timely hearing after the foreclosure. I would encourage the court to read Justice Gorsuch's concurrence, joined by strange bedfellow Justice Jackson, who really raises huge due process issues in total for any forfeiture type of theory. And then finally, a condition for a hearing is filing a motion that it seems relatively odd to me to think about that you have to file something to get something that the U.S. Supreme Court says you're entitled to, and something that occurs after the fact. Right now, all we have is something that, we heard all the excuses about why we have to have notice. As Judge Schwartzel may or may not remember, the excuse given in oral argument in front of you was we need to have that notice so we can decide, the county, the foreclosing governmental unit, can decide whether they can get a steal on their property. That's the purpose of the notice, not so that they can have competing claims, because they can do that anyway, because everybody has to file their motions by May 15 of the following year. So they would all get that notice. So when we look at it and you compare it to other things, you asked me, Judge Schwartzel, what would be, what you could do. I mean, one of the things you could do is simply implead it to the court. Another thing you can do is send it over to the state for them to have it as unclaimed funds. If you look at any of the U.S. Supreme Court briefs, there's references to what happens nationwide. There's only 5 states anymore that do something like what Michigan is doing. The rest of them all have at least a 2-year period for which to make a claim for the proceeds. So there are options out there that I think meet constitutional standards. It would be a much different story if, in fact, once surplus proceeds had been generated, somebody would send a notice and say, well, you have to file by next July 1 or by so many days afterwards, or you're going to lose that surplus proceeds. Now you would probably have a a notice that meets constitutional standards and mandates. I just don't think this meets what is required as recognized in Kent County for minimum standards.
Okay.
And thank you, Your Honor.
Thank you. That case is submitted. Moving on to the 6th matter, docket number 371576, in re petition of Chippewa County Treasurer for foreclosure. Getting a little musical chairs. Morning.
Morning again. For the record, Donald Visser on behalf of the appellant, and I would request 5 minutes for a rebuttal. I don't think I will take as much time on this one as I did on the last one. It's our position that the trial court got this wrong simply because it considered all of the properties owned by Mr. Chevrolet together.
Mr. Visser, I think, not to cut to the chase, I think you have a very strong argument, though I do think the one thing, at least in my mind, I don't want to speak for my colleagues, but in my mind, what does in section 211.778T, paragraph 9, the sentence that says, in order for the payment of remaining proceeds must not unjustly enrich a claimant at the expense of the public, close quote. What does that mean? And how does that not apply here?
I think you're probably going to define that meaning in the.
Well, I'm hoping the legislature at least gave some meaning to it by the 3 or 4 sentences immediately after that sentence.
I don't believe that they did, Your Honor, and I'll give you the background.
I'm literally throwing you a softball here, Mr. Visser.
I understand, but what they talk about in those subsequent standards, I think, expose really what they were thinking. But what I want to tell you is they really weren't thinking a whole lot, because this statute was primarily drafted by the Association of County Treasurers.
But Mr. Visser, I'm going to just stop you right there. That is many people complain about what our legislature did. And what I'm suggesting to you is that is not our job to sit here and second guess the legislature. If they enacted something, unless it's unconstitutional, we try to follow exactly what they said. And they're a coordinate branch of government. We don't sit there and question their motives when they enact something. So they enacted this provision with, quote, a sentence that says, an order of the payment of remaining proceeds must not unjustly enrich a claimant at the expense of the public, close quote. And my suggestion to you is that the following 4, 5, 6 sentences give some meaning to that sentence. So what would unjust enrichment be? Well, unjust enrichment might be that obligations payable to a tenant are not made. That would be unjust enrichment. If there were any unpaid civil fines relating to the property that weren't paid, that would be unjust enrichment. If there was a state, federal, or local tax collecting unit tax lien on the property that was not satisfied, that might also be unjust enrichment. What I'm suggesting to you is that unjust enrichment actually has some meaning, and some examples are given immediately after that sentence.
Your Honor, you're correct, but I think a much narrower definition of that is set out in 78M.
Okay, what does that say?
Because 78M sets forth that unjust enrichment must be decided on a parcel by parcel basis. And I think that's the big limiting factor here. If you look at.
Are you talking about subsection 8? Or are you talking about some other subsection of M?
No, okay, of 78M, not 78TM.
No, I'm
Okay,
with you.
I'm sorry,
I have
Your
it
Honor.
right in front of me. I'm asking you because as I understand, the thrust of your argument is there is specifically reference to
Could you
property.
please stand behind the lectern?
I'm sorry.
Right. There's reference to a property by property basis in 8B and in 8C. And I recognize that that's a powerful argument for you, but are you relying on some other subsection of M to make the argument you just made to Judge
I
Schwartz?
think the entire structure, because you start with 78M8, which says the treasurer of the FGU must deposit into this account. That's the opening paragraph. And then it says in the tail end of the opening paragraph, the foreclosing governmental unit shall use proceeds in the account only for the following purposes in the following order of priority. I want to give you a little historical context to this. Subsequent to Raffaelli, we attempted on behalf of numerous claimants to get the remaining proceeds from the treasurers. The treasurer said, oh, we can't give you anything because 78M doesn't allow us. We don't have statutory authority to do so. Despite the fact that Raffaelli had said the GPTA, to the extent it doesn't allow you to return it, is unconstitutional. It didn't say that 78M or 78X. It said to the extent that it wasn't allowed, but they kept saying, well, and we're working on a legislative solution. So what was the legislative solution? 2020 PA 255 and 256, which modified 78M just a little bit and added 78T. And so it now says, if you put that in conjunction with 21187B1, which says the treasurer has no ownership and holds it in a trustee relationship. Now you say this is what you must do. And you notice that it goes by a property by property basis.
Yes.
And then you jump over to 78T, and it doesn't talk about properties ever. It talks only about property. It's a singular use over in 78T is subsection 9. And then it goes ahead, it says subsection A. So you're looking at the priority. For each property, subsection A is for each property. Okay, subsection B, for each property, and then it ends with sold on a property by property basis. Subsection C is payment to claimants of remaining proceeds for the year ordered under subsection 78T, and any other payments ordered under section 78T must be paid on a property by property basis. So now when we go back into the sentence that says about unjustly enrich, now all of a sudden you are by definition limited to a property by property basis to say when you look at unjust enrichment, how can you expand beyond the blinders of a property by property description? That's why I'm saying the integration there, I think, more narrowly defines what you must look at. So then you get the language after what you cited, Judge Schwartzel, describing what might fit in, but I still think that's by property basis.
I don't disagree with you. I don't think any of the sentences that I read to you suggested otherwise.
Yeah, no, so that's where I guess my head was, is that by the time you look at that sentence and the remaining sentences, you're locked into a property by property analysis.
Right, I agree with you as well. We're just trying to make sense of this language here about unjustly enriching someone, that's all. I mean, there's no doubt that if we rely on subsection 8 of section M, you win. I mean, it clear as a bell, it says property by property basis.
Well, and
We're just trying to reconcile that with the language that seems, although Judge Schwartzel's given an excellent explanation of why it doesn't, but it seems to suggest that this sort of outcome dictated by property analysis could unjustly enrich the property owner.
And so for my analysis, when you even look at just that sentence alone, you have to look at it on a property by property basis to see if there's unjust enrichment on a property by property basis, because that's where you're locked in.
Right.
And I think at that point where the trial court went, there could be millions of other reasons why they might want to try to squeeze something in, but where the trial court went on this one simply could not have been considered.
I know you follow this law, the development of this law very closely. Has this issue come before the Court of Appeals in any prior case? I really worked and I couldn't find anything.
It has not. There's a tangential one having to do with maybe arguing next month. I'm not sure. Having to do with claiming attorney fees generated after the sale and after everything as to whether that is covered by unjust. It'd be a tangential.
But this is truly a question of first impression.
It is, to my knowledge. Thank you all.
Thank you.
Good morning, Your Honors. Lucas Middleton on behalf of the Chippewa County Treasurer. I will say we heard you loud and clear in the last argument. No more Muskegon County stuff. We found a new thing to disagree about, Mr. Visser and myself. So I will say I disagree with the claimant's assertion that the analysis under 78T is dictated by the language in section 78M. And as a larger point, I would note out that the claimant conflates the delinquent tax revolving fund established under MCL 211.87B with the sales proceeds account, which is a distinct account established under section 78M. So I would note preliminarily that those are different accounts subject to different requirements under the General Property Tax Act. Section 78M lays out, and this colloquially is referred to by the treasurers as the waterfall So the way in which proceeds that are collected at tax auction are accounted for and are applied, how the delinquent tax revolving fund is reimbursed, how when proceeds are ordered by the court, how they are accounted for and paid.
But once the forfeiture has taken place, that resolves the tax payment, correct? Or the tax debt, correct?
It moves it into a new realm of collection, which is through the foreclosure,
Yeah, but
the sale of the
I guess,
property.
let's just say there's one piece of property
Correct, yes.
and the taxpayer fails to pay taxes on it, it's foreclosed on, it's sold, and let's just say it's sold for, $500 less than the tax owed. The taxpayer doesn't, you don't have, the township doesn't have any legal right to go after that $500, doesn't?
They do have a right under the General Property Tax Act, and I apologize, I don't have the citation
Okay.
at top of mind. It's never, in my experience, not utilized or seldom utilized, but there is an ability to pursue personal recourse against the taxpayer that is
That's against the taxpayer.
the owner of the property.
Okay.
So technically, yes, that debt could be collected against the former owner. It's through, there's a statutory mechanism in the General Property Tax Act for doing that. And that's not at top of mind, so I apologize, I can't provide
But I
all
guess,
the details.
other than that circumstance, how does the township justify what it did here?
I think it can justify because of the language in 78T, and I don't think 78T, the analysis is explicitly required to be a property by property analysis when you're considering unjust enrichment. The taxpayer here owned 20 parcels of property. They were all foreclosed upon. He owed taxes on those 20 parcels of real property. They were sold for less than the taxes due. So in any way you slice this, the local unit of government has not collected the full amount that they were due. It's a difference between a $3,000 loss and a $6,000 loss.
But to my point, did they have the legal right to go after that delta?
Yes, I believe they did because of the language in section 78T, and I understand your point.
Set 78, set the unjust enrichment. I mean, your bootstrap. I mean, I'm asking you, set aside the unjust enrichment component. Did the township just have the separate right to
There,
go and recoup all of the full taxes owed, even after the forfeiture and sale?
yes, it is my understanding under the General Property Tax Act, there is a mechanism for seeking.
But they didn't follow that mechanism here.
Well, this is the county treasurer that's involved in this action, not the township.
Okay, well, the county treasurer didn't follow that. I mean,
Correct, correct.
okay, so if you think that there's this other mechanism, but it's for a certainty that that mechanism was not followed here.
Again, Your Honor, I apologize. This issue wasn't briefed and I don't recall whether that avenue is available to the treasurer or whether it must be pursued by the local unit.
How long does this right go on? In perpetuity? Is this like intercepting a tax refund year after year after year to settle a delinquency on income tax payments?
Are we talking with respect to the argument under 78T for unjust enrichment?
Whatever the case may be, why ever you would claim a right to recover what appears to be surplus proceeds from a parcel.
My argument would be that it would be within the foreclosure case that is at issue with respect to those proceeds.
But the proceeds are generated by the foreclosure sale of the particular parcel, right?
Sure.
And it's on a property by property basis. So if we were to look at this situation, never mind the aggregate, on an individual basis, there are 4 parcels that generated surplus proceeds, right?
Yes.
And presumably, if this is done on a property by property basis, you have to give that money back to property owner, right?
Correct.
Okay, so leaving aside the argument about not unjustly enriching the landowner, is there any other claim that you could assert to get that money back? I mean, to essentially intercept it.
There's not one that I'm aware of that the treasurer could utilize. I believe the only mechanism for them to do what they did was through 78T and through the,
Okay, so in essence, then, the money would have to go back to the landowner. And then the foreclosing governmental unit would have to come up with some basis for bringing a collection action separate and apart from the foreclosure action, right?
yes, but that essentially is unrelated to the remaining proceeds in that.
I got
particular
it, I
case.
got it. But you know, there is this pool of money out there because you just gave it back to the landowner, right?
Correct.
But that's how you'd have to do it. You have to give it back to them in the first instance and then avail yourself of whatever remedies you might have for collection otherwise, correct?
In the scenario you described, yes.
Okay.
I mean, this doesn't seem that far afield of the county just going and taking this gentleman's car. Well, you know, he owes taxes and we didn't collect enough on our property foreclosure sales, so we're gonna go take the car. And while we're there, maybe we take the refrigerator and a TV too, because, you know, he owes the money. It gets very scary very quickly if this is not a property by property analysis. If we're just kind of lumping all of his property together, I don't see why we're not lumping all of his property together, not just the ones that were foreclosed upon, but anything else he has.
Well, Your Honor, I think in this particular situation, we're dealing with a very circumscribed situation. We're dealing with these specific parcels that went through this specific foreclosure
So with
action that
regard
were
to
sold at.
So with regard to these specific parcels, did any of them have a tax lien either by the federal, state, or the locality on the parcel that had priority over the claimant's interest in the property?
I know that the 4 parcels at issue did not have such a lien.
Because that is a specific instance in which our legislature said, yeah, you can go after the proceeds. If there's a tax lien that has priority, wouldn't that be an instance of if the claimant wasn't subject to that the claimant would be unjustly enriched?
Your Honor, I push back a little bit with the interpretation that those following sentences are specifically intended to flesh out the meaning of unjust enrichment. I believe that those are separate enumerated instances where the legislature has deemed it appropriate to pay other entities. We call it colloquially piggybacking on the claim that somebody else has made. So the state of Michigan gets to do that with a tax lien. The federal government gets to do that with a tax lien. They just get paid automatically. But I believe that the legislature included this provision regarding unjust enrichment to provide some flexibility to the circuit court in the very broad scenario, which is tax foreclosure. There are innumerable different situations which could arise with respect to various interests in the property, with respect to, as you know, property touches every aspect of our lives. So there are always situations that we encounter in tax foreclosure, which you may not necessarily anticipate. And I don't think the legislature could rightfully prescribe exactly what situations may fall under this rubric, but provide some discretion to the circuit court to interpret when unjust enrichment might occur. And
Let me suggest this reading to you and you tell me why it's wrong. As I read this, there's that very broad sense about unjust enrichment. And then it's followed by, I think, very specific instances that could be characterized as if these weren't followed, the claimant would be unjustly enriched. But all of that is on a property by property basis. It always talks about the property, not properties as an aggregate. And so even if my reading is not the best one, it's still, I think it's unassailable that it always speaks about property. And so to Mr. Visser's argument, you have to look at unjust enrichment within the context of property A, property B, property C, not properties A, B, and C. So why is that property by property analysis just incorrect?
I think, again, that I would loop back to that I believe that the broadness of that language is intended to encompass the various situations that you might encounter. And so in my supposition, in our position, the treasurer's position is that this particular taxpayer owed $15,000 in taxes. Those properties were foreclosed upon and the government had collected $11,000 in taxes. Why is it not unjust to pay this taxpayer $2,000 when the local unit of government then suffers and the public at large suffers a $6,000 loss? I would characterize that as unjust at the expense of the public, and I believe that it's an acceptable interpretation of the language that the legislature has provided to us. I understand that it's somewhat uncommon that a taxpayer or a claimant would be proceeding with more than one property. The vast majority of claimants' cases are one parcel of property. That's all they owned. This claimant owned 20 parcels of property. And I should say throughout the proceedings, they treated these properties as a collective. They took title to these individual parcels of property on a consolidated deed. They filed a single consolidated notice of intention to claim proceeds for 17 parcels. They filed a single motion to claim proceeds with respect to 4 different parcels. So these properties in many ways were treated in a consolidated manner by the former owner throughout these proceedings. And I believe that it's
But there's no question these are legally separate parcels, correct?
Yes, they were assessed separately.
I don't have any additional questions. I mean, it really just comes down to statutory analysis and, you know, trying to make the most sense as possible of this statute. So we appreciate you coming in. Mr.
Thank you,
Visser, you
Your
have a
Honor.
few more minutes for brief reply.
First of all, I try to answer the court's question regarding the FGU's attempt to collect outside. I am unaware of any statute that would allow the FGU to file an action for deficiencies.
Once the foreclosure, that's, in your opinion, that satisfies the tax liability.
Well, it doesn't satisfy the tax liability because it's shortage, but I know of no provision because the taxes originate with the local unit of government. They're then turned over. The treasurer funds the treasurer, the local unit of government. But I know of nothing once a tax sales occurs that they can go after the individual. Just
To get the delta.
That's correct.
Okay.
The second issue I'd like to quickly address is something I'll make just real quick comment of the other language in the statute says at the expense of the public. I think it's really odd that the FGU would be arguing this is, I made a record at the trial court. The treasurer received positive delta. We know under Raffaelli that money doesn't belong to the treasurer. We know under MCL 21187B1, it doesn't belong to the treasurer. I don't know how you throw in at the expense of the public if it's coming out of property that doesn't belong to the treasurer. It belongs to there's some other people that didn't get their money. But you start talking about property getting paid out of somebody else's surplus. The total surplus was positive for all the properties that were sold, and not everybody made a claim for their surplus. So the treasurer netted money out in this particular year. There's no loss, and as far as considering claims, I think once that door is open for looking at other things. what's unjust or whatever else, I would talk in, well, let's look at unjust enrichment. Raffaele says it's unjust enrichment. So did Dean say it's unjust enrichment for you to keep any surplus? I mean, all of a sudden the door opens hugely if you go beyond a parcel by parcel basis to look at things outside the sale proceeds of the taxes. Thank you.
Okay, thank you. That case is submitted. That finishes our 10 o'clock part, and we are going to take a brief recess. We'll be back in 5 to 10 minutes. Right, we are here for the 11 o'clock portion of this morning's case call. I'm not going to go through any big instructions other than if you're representing a minor, to make sure and use the term minor or use that minor's initials only. So with that, I'm going to call the 7th matter on our docket. Docket number 372910, Cheney v. Meritage Hospitality Group.
Good morning, Your Honors.
Morning.
Do we have the appellee up? It says he's appearing remotely.
Hi, judges. I just promoted him to the panel and he should be showing up in there soon.
Shall I wait?
Are we going to see Mr. Anthony? If he's?
We should.
Okay.
Let me just, you asked to do second.
Who do we have who's working IT right now? Well, she's like the Wizard of Oz. If she can hear us.
Yes, hi, judges. I don't know why his video is not on. I just asked him to turn it on though.
There we go. Mr. Cheney?
Yes, Your Honor.
Okay, we can see and hear you clearly. We appreciate you appearing this morning. You are not endorsed, but you are here if we have any questions for you. But Mr. Brodus, as the appellant, has the opportunity to go first. So let's hear from appellant.
Thank you, Your Honor. Drew Broadus for the defendant appellant. This is our appeal from summary disposition ruling. Oddly, it's an appeal from the granting of my own motion because
I did wonder
yeah,
how this got here.
and the issue is, we're in a grief party because we asked for with prejudice dismissal under C10. Trial judge granted it without prejudice. And that has ramifications, not in the record, but the court can take judicial notice of the fact that Mr. Cheney has filed a new suit based
What
on
about
the
the
same.
fact that discovery had not closed?
Well, that might be a reason arguably to deny a motion under C10 if there's reason to think discovery would lead somewhere. It's not a reason to grant it without prejudice. There's simply no authority for that outcome. And I cited a couple of Court of Appeals published cases, nothing from the Supreme Court oddly, but talking about C7 and C8. I think the rationale of those cases applies even more forcefully for C10 because that's a situation where you either show what materials you relied on for bringing the client, or there's a procedure where you file affidavits saying, here's what I think more discovery would yield, which wasn't employed here. So what we have is a record, and we did some discovery and it was open, but it wasn't as if we just filed this as an answer.
Just to be clear, there's some summary disposition motions under 2.116C, which are without prejudice. For example, C4 for want of jurisdiction. If we have no jurisdiction, we can't render a merits decision.
True.
But your position is C10 is the ultimate merits decision, if you will.
Exactly. And it's analogous to Rule 56. There's federal case law I cited that talks about that. Yeah, I'm not saying, to be clear, I'm not saying you should declare that all summary dispositions. I think C6 is also in certain situations can be.
I think I've even seen C8 on occasion. But I understand that that's not this case, so we
Right.
need to get into a big discussion about it.
Yeah.
But C10 does seem to be kind of your prototypical on the merits.
Right. And that's my argument in a nutshell.
I have one procedural question, because I think since you were the prevailing party, the trial court invited you to submit a proposed judgment. And I presume if the proposed judgment says without prejudice, that was just following the directive of the court.
Correct.
It wasn't any sort of decision you made to declare it without prejudice.
No, if you look at the hearing transcript, I can give you a page,
Right.
but it'll take a second, but.
Yeah, no. I read it last night.
The trial judge specifically said, I'm doing this without prejudice because discovery's ongoing.
So even if one were to make the argument that you submitted the judgment, so you're stuck with it,
Right.
your response to that would be, we were conforming the judgment to the oral pronouncement of the result.
Right. It's no different if I had lost the motion for
Right,
fact
sure.
questions and submitted the order, and I would expect the judge to instruct me to prepare that order with the pro se litigant. It would just make sense.
Did the trial court address the ongoing discovery in the context of granting the C10 and indicate that the trial judge didn't believe that any additional discovery would call into question whether C10 should be granted?
He didn't get into that. He simply cited the fact that discovery was ongoing and the fact that the plaintiff was representing himself were more or less just the reasoning of why it was with versus without prejudice. But he recognized that, we had carried our burden as the movement. There was really nothing as the non-movement to rebut the burden or to create a fact question. He acknowledged all those things and then got to the end and then said, but for these other reasons, I'm going to give him a chance to refile. And he specifically said, I'm giving him a chance to refile.
You said he has refiled, and I know this isn't in the record, but did it go to the same judge as the related case, or did it just get assigned by blind draw to somebody else?
It went to Judge Noto again because he's getting all of the cases that relate to
Right.
E. coli.
As a related case. I got it. That's what
Well, and because there's more than one, there's a backstory to this that it isn't in this record, but the court that may take judicial notice of. There's other E. coli cases dealing with Wendy's at other locations, different times.
Oh,
They're all being sent to him, irrespective of whether there've been a prior filing. In this case, you'd have two reasons to send it to him because they're doing it that way at Kent Circuit
got it.
because of the E. coli aspect, then also because of the prior case. So it's front of him. He stayed that this is all just stuff that's not in the record, but in the case the court is interested, he stayed that case under C6 pending the result of this appeal.
Okay.
So that's where we stand. The new case is the same facts. It's just some new parties and a bigger complaint. But again, we're still at the same problem of did this plaintiff ever get E. coli and why did he get it?
Any more questions for Mr. Brodus?
No, thank you.
Any questions for Mr. Chain or Mr. Anthony?
No, thank you.
So Mr. Anthony, we appreciate you coming on and being available for questions. This is a pretty straightforward and it's primarily a legal question. And we're going to take a look at it and we're hoping to get an opinion out within the next few weeks. So, because we know that we don't want to hold up anything. We understand that there are other proceedings that this will impact. So we appreciate both your time and that case is submitted.
Thank you, Your Honor.
Thank you very much for being here, sir.
Calling the eighth matter for this morning, docket number 373193, Bluffs at Gull Lake LLC versus Ross Township. I believe the township.
Good morning, Your Honors. I'm Rob Thal. I'm on behalf of Ross Township.
Morning.
And what I'd like to do is make a few comments on I think we've addressed our issues in our briefs and our reply brief, but I'd like to make a few comments in regards to the case and then answer any questions the judges might have. So in this case, it's kind of a unique case. Zoning is unique in itself, but this is kind of unique even in zoning where you have a split parcel, a split zone parcel. So part of this parcel is R3, high density residential. Part of the parcel is low density residential R1. And so in this case, how you deal with it is a little unique. The Anchor Steel case, I believe, addresses this issue. And in the Anchor Steel case, it tells us that we have to look at the zoning in each of the split zones. And
Where should the walkway go? Where should the walkway be? I mean, if it's not gonna be where the Bluffs want it, should it be along, what is that, M89?
yeah, so they
So
have,
so do you really want people walking that close to M89 if there was a kind of a safer place where this walkway could be?
well, I think that is where their public access is. So they have a site plan. Site plan has approved access to the site, which is off of M89, which is a state highway. They could develop, and there could be a process with the municipality, with the county, with the state, to develop a walking path or a bike path or something publicly owned or otherwise along M89.
I mean, that's a fairly busy highway. I mean, and is that at that area, what's the speed limit for M89?
Oh, I would say it's probably 55 in that area.
Right. I mean, does that sound like the best place to put a walkway for people living in this development? If
Well-
there's a alternative that could avoid that kind of high high speed traffic?
So I go back to the planning commission because they actually did look at these issues and they were discussed at the planning commission. They did discuss different access back to this local side road D Avenue, which abuts the rear of the property. And whether or not, they could have access through, there's a commercial parcel that butts up to their parcel too, that we looked at, possibly having access through that, or this other R1 area. And those things were discussed at the planning commission, but ultimately the planning commission did not, and I don't think they pushed the issue either, but the planning commission did not approve any type of access back off of the parcel back to D Avenue. And that should have been part of the site plan if it was something that was going to be approved.
What's the township going to do if people just start walking from the Bluffs to D Avenue? No walkway, they just wear it down. I mean, you've been around a college campus, you know how this goes. The most logical route is the one that gets worn down.
So, I mean, this is kind of, that is an issue. We've talked about that issue at the township level. It's like, okay, what are you going to do if people do walk on it? That's a great question. And the fact of the matter is you'd go back to the property owner, the apartments, and say, look, this is part of your entire site, but you can't have a public walking path. And part of it is it's a privately owned public walking path over this parcel. Now, the ZBA analyzed whether that is a permitted use of the R1 parcel.
They can't walk. I mean, they own the property. So Bluffs owns the property,
Right.
but it's just this one sliver is zoned R1 versus R3.
Yes.
And you're suggesting that the tenants can't walk if there's too many? Maybe one or two, okay, that would still be R1, but boy, if 10 walk in this.
I think it goes to the fact that it's a public trail or a public walking path, not just a private owner walking on their property. This would be considered a public walking path. And under the zoning ordinance itself, if you look at in the R1 in section 6.3F, there is a use for publicly owned and operated buildings and uses, including community buildings, public parks, playgrounds, and other recreational uses. This is very similar to a park-like use to walk through this area.
How is this not an accessory use?
Well, it could be, it could be accessory to the R3 use, but the problem is it's going over a R1 zoned property.
So I mean, R1 has certain use, quote unquote, uses that are permitted, but an accessory use It gets confusing because we use the word use, but an accessory use is not a use under R1 or R3 or anything else. It's incidental to the purposes. And how is this not just an incidental use of the property?
So they do have an accessory use as a permitted use in the zoning district is accessory uses, but that's understood to be accessory to those uses in the zone. So if you have a home, a single family home in the R1 district, what's accessory to that use? You can't just pull in other accessory uses. It has to be accessory to those that are permitted in the R1 district. And I think that's what the Anchor Steel case talks about, in that we have an industrial parcel in that case and a commercial parcel in that case. And they allowed them to put a commercial building on the commercial parcel. They wouldn't have let them put an industrial building there, to go with the industrial use, but they allowed them to use it for commercial purposes because that's what's permitted in that zone.
But this seems so very strange to me. So you could have all these people congregating on the R3 portion of the bluffs, whole bunch of people. Two of them decide to go across D Avenue to go get a bag of ice. If two people go, it's fine. If 8 people go, it's not fine because it's R1 for that little strip.
Well, I don't think they can use it at all associated with their apartment complex purposes. The high density residential purpose is the apartment.
So what you're saying is even
They
one
fence it
person can't just stand on it or put down a towel and sunbathe or something.
Well, because then it's a public recreation area, a public walking area. It's changing the use of that R1 parcel. So, yeah, I mean, we would ask them,
It's-
we would ask them to fence it off.
Excuse me, it's an impermissible use for R1. Let's say there's no home on it. It's just an empty lot, R1, empty lot. It's an impermissible use for a person to walk across that lot.
To do that as a actual use, like to create a path and say, we're going to use this as a pathway. It's not just somebody walking across it. It is a trailway.
So
It could be
any
a recreational.
pathway on an R1 lot in Ross Township is in violation of the city ordinances?
If it is not part of a permitted use.
Well, let's just say, I live in this township, I have a house, and I let the neighbor kids cut through the corner of my back lot and it kind of gets worn down. So I am now in violation of the city ordinance?
I think the difference here is that it's an amenity to an apartment complex. It's not just somebody.
But wait a
walking
minute,
across.
you just said any R1 township or any R1 use beyond kind of a single unit residential is in violation. So I'm just asking, if I own a single unit R1 lot, I have a house and I decide, you know what, I'm going to let the neighbor kids cut through my backyard. I like having kids in the backyard. I want to watch them play baseball or whatever. So sure, they can cut through my backyard. I'm now violating the township's ordinances.
I don't think under those circumstances that would.
Why?
Because it's not used for a specific purpose like a park or if we do have provisions in there, if you want to have like a park or walking area or preserve or whatever it might be, it allows for publicly owned and operated buildings, including community buildings, public parks, playgrounds, other recreational uses. It's the intensity of the use really here. It's a R3 use going over this R1 property right next to somebody's home. And so, it's not just 1 or 2 kids, that you allow as guests on your property.
How close would the proposed walking path be to a residential house?
It's right next to it.
I don't know what that means.
Well, I think if we.
Give me, just 15 feet, 20 feet, 30 feet. What are we talking about? 5 feet?
There is a drawing in the exhibits that does show the parcel, and it shows the structures, the homes on the parcel, that it goes through.
Okay.
So
maybe
you
can look at it. You don't look at it now, just, in your reply, if you want to keep any time, you can maybe answer it then.
But I just don't understand why that view of it is the efficient way to handle the problem. I mean, if you put down a cement walkway, it will be evident to everybody, including the people buying the houses right along it, that it's there and it's going to be used. If the alternative is you can't put the cement walkway down, but people being people are going to be logical and they're just going to start cutting through there, then you've got exactly the same result, except the homeowners don't even know that they have to deal with that problem.
Well, they would come to the township to complain about it, and we would ask the apartment complex to fence it off or, say that it's not a pass-through or something of that sort. And the onus would be on the apartment owners to control their residents. Because it would.
But to be clear, their residents would not be trespassing under Judge Yates' hypothetical. They would be walking on the apartment's property, just they would be potentially, in your opinion, violating a zoning ordinance.
Correct.
Okay. Okay. Did you want to keep any time for your reply?
Yeah, I'll go back and look at the maps.
You've got about 5 minutes.
All right, thank you.
Yeah.
Well, Your Honors, Tom Ammon on behalf of the Eppley, the Bluffs. I think Your Honors have covered a lot of the issues. And our argument, I believe in this case, is pretty straightforward. And that's why the circuit court judge saw this for what it is. There just isn't a restriction here at play. I did want to address a few of the issues that that came up. I think,
What about the fact that under your proposed use, there is at least a relatively high, however you define how high volume, but assuming, there's a decent number of tenants in the apartment complex and they're going to want to get to downtown, it's going to be, presumably a decent volume of people, and they are going across an R1 zoned piece of the property. How is that not against the character of the R1 zone?
Well, I think, I guess a couple of different points to that. I don't think that the township's position is simply this is out of character with the district, and that's not why they made the decision they did. Their position is that you cannot use that area at all for a pedestrian walking path. And basically their position is that it's an anti-funneling issue, right? And the township is asking its ordinance to do a lot of things that it doesn't say it does. And elsewhere, when the township has regulated funneling, when they've said, hey, where it comes up is lakefront property, and they have an entire section of the ordinance with restrictions on how many people you can funnel to a waterfront lot because of the same issues, right? The township is saying, hey, this causes issues with neighbors, it causes all sorts of problems, so we're going to regulate it under this. I think this is fundamentally different because it is accessing a public right-of-way that is on our own property, that abuts our own property, and importantly, this is all the same lot. So the township's attorney came up here and said, well, this is more like a public park or something like that. But that's really missing the point. Zoning is lot by lot in the township. So our entire lot is regulated as a lot. And the principal use of that lot is high density residential, is R3. And there's no dispute about that. And the way that the ordinance defines uses is exactly that way. The principal purpose for which the lot, and it uses the word lot, is maintained. And if you look at the definition of lot under the ordinance, it's not based on zoning district. It's based on the legal description of the property, how it's separated from the surrounding properties. So all of this is happening within our own lot. We're not proposing to change the principal use to a public park. And this is a new theory. I mean, this is kind of the township's latest iteration of its arguments.
And I presume that this is a common area.
It is.
If you think in terms of an apartment complex, there's some things where the units actually belong to the tenants. This is just common area in the sense that anybody who has an apartment there is entitled, at least in your view, in terms of trespass, to be on that property.
Correct. And in fact, from the very beginning, from the very outset, and there's some of this in the record that we went through in our brief, this was a very important part to my client. A very important aspect of this development is that we'd have walking paths that people would be able to walk to the surrounding area. And back in 2022, when this was originally proposed, the township was receptive to that. They
You're talking
said,
about the planning commission now.
the planning commission, correct, was receptive to that idea. They thought walkability was a good thing here. And originally they were speaking in terms of going over the neighboring commercial area, but when the township didn't deal further with that, there was a suggestion that the township would give us an easement, and that just never materialized. We said, okay, well, we have property abutting, our property abuts D Avenue, so that's where we'll put the walking path. And then it kind of, the tune was changed and now we're here today.
What is, I think I asked opposing counsel, how close would this proposed walking path be to other existing R1 residential homes or units?
So it goes between, right, and I don't have the exact measurements for you on that, but it does, it's a piece of the property that goes between two lots, and they're long lots that are also dual zoned. Because there's this kind of strip of R1 that goes along D Avenue. I can't get you the exact measurements, but my recollection, my client has been working, since this ruling, my client has been working with the township to get the walking path in place. And they've worked through things like screening and things like that. And actually in the circuit court, we had some discussions about that on the record, what kind of
I guess
screening.
my point is it going to be 5 feet on each side is going to be an adjoining house? Or are we talking 20 feet? Like, how is this impacting the character of those residential units?
Right. I think the answer to that is there is sufficient space to put like some hedging and screening in place. I can't tell you exactly how many feet it would be to an adjoining house. I think it's just one house is my recollection. But there is enough space because I know that my client's been having direct discussions with the, I believe it's the zoning administrator at this point, talking about, okay, what hedges can we put here? And it's really just to avoid disturbing that landowner because we don't want to create a disturbance here. I mean, we're just trying to provide the most direct, safest access for the residents to the downtown area.
You talked about an easement. Was that in a different location? Because if you own this property, wouldn't it be a variance rather than an easement?
Yeah, so if it's, so the original discussion is we believed that the township owned some property to the east of this development.
Oh, okay. So it would be an easement over township.
It would be an easement over township property, and I'm not sure how the zoning issue plays out there. I would submit it's kind of proof that their position here that you can't have a path over
Right.
one zoning, like that doesn't play out anywhere else except for here where they want to prohibit our pathway.
Right, because if they were to facilitate your use of the R1 little bit of land the way that you want, I guess you'd have to get you'd have to get some sort of concession from the township, and presumably it would take the form of a variance, right? I mean, you'd have a variance on that weird little piece of R1 property.
I don't think we need a variance for it.
I don't think you do either. I
Right.
think you just win for the reasons the trial court said, but
Right.
if they want to frame it that way, then they have to consider an application for a variance from you if you want to insist on trying to do this, right?
I mean, if they were correct that this wasn't allowed here, we would have to seek a variance to get it. And given the way things have unfolded, I have little confidence that we would
Right.
get that.
You read my mind.
Right. I mean, I just don't see how they would say this doesn't, I mean, the variance standards are very broad, and if they want to deny a variance,
Sure.
they have a lot of discretion to do that. So,
Any other questions?
No, thank you.
Okay, I think that's it.
thank you, Your Honor.
Stahl, you have time for a brief rebuttal?
All right, thank you, Your Honor. So what I would say is if you look at Appendix 2 of our appendices, in there it shows where the homes are located abutting the property, and the home is directly on the property line. So maybe
Okay.
I would estimate 10 feet, as a side yard setback. And that is a issue with that homeowner, obviously, is having R3 high density intensive use right next to their house. I mean, that's something that person is going to have to deal with. They thought it's a R1 property next door, can only be used for R1 purposes. With regard to some other comments, the public aspect of it was actually discussed in the ZBA. So council said that it's kind of a new theory, but it actually was what the ZBA made their determination on, is that it was most similar to the public access or the public provision that was allowed in the R1, except it's not publicly owned and operated. It's privately owned and operated. If it were publicly owned and operated, maybe it could be a permitted use. And that's in section 6.3F of the zoning ordinance. You know, under their theory, could they put a tennis court there if they wanted? Could they put other amenities if they want? You know, our theory is you have to be R1 uses. They can't just they say walking path now, but what's the difference between that and if they want to put tennis courts there?
Okay,
All right.
thank you. That matter is submitted. So we have a consolidated set of two cases next. Docket number 368812 and docket number 368816, Bronson Healthcare Group versus Conifer Insurance Company. And I believe we are going to get into the fascinating world of Medicare secondary payers. And it is officially afternoon, so good afternoon.
Good afternoon. Thaddeus Morgan on behalf of Appellant Conifer Insurance Company and Cross Appellee Conifer Insurance Company.
Do you want to reserve any time for reply?
Yes, please, 5 minutes.
5 minutes.
So this case has been fully briefed. As you can tell, it's scintillating stuff to read. We're dealing with a statute, the Medicare Secondary Payer Act, that is certainly not a model of clarity. But I think with that said, if you look at it under the facts of this case in the context of the Workers' Compensation Act, the conclusion, I think, is that both Bronson and the trial court jumped the gun, got the cart before the horse, whatever metaphor you want to use, because Bronson's complaint was filed in 2020. The work comp magistrate did not issue a ruling until 2023. And then after that, the trial court said Bronson is entitled to double damages under the MSPA.
So just could you update us? Has there been any decision by the appeals?
The appeal commission matter remains pending, which was the reason for my motion to put off today's hearing.
Has there been any, I'm sorry, has there been any? What I don't want are two entities both waiting for the other entity to act and then nothing gets done for years. Is there any belief on your part that the appeals commission is waiting for something from us before they decide, or?
No, I've been in contact with Conifer's work comp counsel. He just says they're a little behind.
Okay.
Maybe too far behind.
Okay.
Okay,
I just want to make sure they weren't waiting on us and we weren't waiting on them.
you.
Okay.
And it's been fully briefed and they're just waiting for a decision from the appellate commission, which I think, you know, obviously there's the prospect of inconsistent results here. And I don't know how that's going to play out because, you know, collateral estoppel has been argued ad nauseum in this case. And I conceded that collateral estoppel would apply once we get to a final adjudication and a final decision, including the appeal.
Right.
Which was the rest of my statement.
Right. And that's the question I want to ask. What, in your view, is a final determination that would have collateral estoppel effect?
It would be.
How far do we have to go down the tracks?
It would be a decision from the appellate commission, either denying, reversing, or affirming the magistrate's decision. Because an appeal from the appellate commission is by leave to this tribunal. So I would submit, and that was the basis of my statement to the court, that, you know, I agree collateral estoppel could apply at some point when we get a final adjudication.
So you can get a final adjudication at the administrative stage. You're not going to try to run it all the way up through the U.S. Court of Appeals and wherever else you go in an administrative determination.
Correct. Correct.
Okay.
But with that said, Your Honor, according to the act, benefits accruing prior to award are withheld pending appeal, and that's MCL 418-862. So I mean, that means that Conifer has not been on the hook and cannot be on the hook for reimbursement for Medicare payments, much less double damages, unless or until the commission makes its ruling.
And at that point, I think you would take the position that you have the option then of making the payment.
We have,
And that would obviously leave you out the money, but it wouldn't put you on the hook for double damages.
correct. You have 60 days after there's a finding. I mean, the whole idea behind the MSPA was to, for lack of a better term, punish recalcitrant insurers who don't step up to the plate. And in this case, I submit Conifer had a very good faith argument, and I'll get to this in a minute, that the deceased, Ms. Roach, was not in the course and scope when the incident happened.
Well, and I think, reading biomedical, the Sixth Circuit case, there was no real question about coverage there. I mean, the insurance company in that case really tried to write a statute or write a contract that was in violation of federal law. And so I don't know that I don't recall the argument being framed in that there was a good faith dispute over coverage. Where I have read, there's a Ninth Circuit case involving DaVita, and apparently DaVita is involved in all kinds of these cases. This is DaVita v. Virginia Mason Memorial Hospital, 981 F. 3rd 679. And in dicta towards the end, that panel indicated that a good faith dispute over coverage would not be the basis for a double damages private action claim under the MSP.
Correct.
Now, if the insurance company acted in bad faith, they can't use that as a defense for not paying. But if you have a good faith basis for questioning coverage, fraudulent activity, coverage ended, person wasn't an employee in your opinion, then that wouldn't necessarily trigger the responsibility to pay at that time until that good faith dispute was resolved.
Correct. You're not, I got to look at the phrase here, but you're not, it's a term of art under the MSPA.
Determined responsible or determined responsibility or something like that.
Right, which is a key element. And there's a distinction because as you point out, Your Honor, if you have a contract, for example, PIP coverage, it's clear and there's no defense, there's lack of domicile, unauthorized user or something like that, then arguably then that no fault insurer is on the hook. But here I submit there's a bona fide dispute. And I'm not going to regurgitate the magistrate's 20 points that she went through to determine that Ms. Roach was an employee and not a volunteer. But there's also a distinction between statutory obligations and contractual. And here we're dealing in the workers' compensation realm, which is a statutory animal that has its own rules and procedures, as opposed to just merely looking at a contract and some facts. So you have to go through and litigate it, which Conifer did, and the magistrate made its decision, or the workers' comp down below made its decision. And so that's a distinction as well. I think if you look at the MSPA case law, it talks about, for example, a tortfeasor. Until that tortfeasor is adjudged to be liable, there's no obligation under the MSPA to pay. And here, as I said before, whenever the compensation or the appellate commission makes its decision, Conifer still has 60 days to pay.
Well, and I think, maybe too much time was spent on this whole tortfeasor issue because there is no tortfeasor here.
No,
I mean, this isn't a question of tortfeasor, but there is, I think, and I'm interested to hear from opposing counsel with regard to what happens when there is a good faith dispute over coverage. And at least reading this Ninth Circuit case, they certainly suggested that that would not give rise to an MSP private action for double damages until that good faith dispute over coverage was resolved. And we might be getting to that resolution, or maybe we got to it. Maybe the AL, the trial court, to its credit, didn't just, come up with this whole cloth relying on the ALJ or the magistrate. I forget the term that they use now.
Magistrate.
I think there's case law that suggested that, but that was pre-November 1st, 1990 case law, if I could recall correctly. So we're not necessarily bound by it, I guess that's what I'm saying.
Bottom line, there's been no final determination as against Conifer.
Like, can you play this out procedurally though for me, Mr. Morgan? Because I'm not fully understanding how we got to where we are. We're up on rulings on cross motions for summary disposition under C10, right? That's what brings you before the court, and you have your own appeal of the C10 rulings. I would have expected that your position would have been either there's a lack of ripeness here, or there's a lack of jurisdiction, which would be a C4 motion. And yet everybody's engaged on the merits, and now you're in front of us with what looks to me like a jurisdictional problem or a ripeness problem.
Yeah, and Conifer in their briefs said that we didn't file a motion for stay. That's incorrect. If you look at the appendix to our supplemental appendix to our reply brief, you'll see in there was a motion for stay. There was at least one, and I suspect, if my memory serves me right, there were two that I filed that were rejected by the court. And that's why I get to my first point, which is both Bronson and the court jumped the gun. And it was part of Conifer's motion for summary disposition and motion for stay. And again, that's attached to our appendix to the reply brief. So Bronson's statement that we didn't file a motion for stay is simply incorrect.
But wouldn't it have made more sense to challenge either jurisdiction or challenge the ability of the court to move forward on ripeness grounds? Because it seems to me that the most logical way to handle this, and maybe I'm wrong, but is send everybody to the dugout and say, you can come back out and play the game once we get a final determination from the workers' comp matter, right?
I agree with that, Your Honor, but I think the trial court was so swayed by the magistrate's decision that Judge Lipsy just wanted to dispose of the case and get rid of it. But again, I think both Bronson and the trial court jumped the gun because we're not there yet. And even if we get there by a decision from the appellate commission, we still have 60 days to avoid double damages.
If you want your 5 minutes,
Okay.
you need to wrap up.
Thank you.
Good afternoon.
Good afternoon.
Rostam here on behalf of plaintiff. I'd like 5 minutes for after this moment, if the court's okay with that.
Yeah, so, I guess we should have figured that out at the beginning. We got appeals, cross appeals, all kinds of fun things going on here. I think it makes sense to just kind of handle everything at once. But if you have something that is directly in reply in support of your cross appeal, then sure.
Well, I can do it that way too. There's two claims of error that my client brings here. One is the way the court decided the RJA interest issue. The court calculated interest from the moment the magistrate made her decision in the comp bureau. That's not right. Should have been from the date the complaint was filed. I think the law is pretty clear on that. I'll belabor the point. The other area of error is the damages offset. So the court gave us a judgment for $293,000, which included, the $2,800 in interest. But then the court said that my client's judgment would be offset in an amount equal to what my client receives in the work comp case when it ultimately resolves. That was error because there's no authority to create an offset for my client's MSP damage rights connected to independent rights it may have under statute for the payment of benefits. Those benefits are compensatory. The MSP damages my client is entitled to are not compensatory. It is a bounty hunter statute that is designed to deter unfavored conduct, punish to the extent necessary, and incentivize plaintiffs with standing like my client to find these cases and bring them to make Medicare whole.
What about when there is a good faith dispute over contractual coverage?
So
When can a private action be brought?
So a private action, I think there's been some confusion by Conifer on the demonstrated responsibility requirement. So a private action under the statute, the MSP statute, accrues when Medicare makes a conditional payment, which is by definition any payment where another payer should have paid, or when a recalcitrant insurer denies benefits to a Medicare beneficiary because that person is entitled to Medicare, which is what happened in Biomed. So that's the accrual. Now, the elements of the cause of action, the private cause of action, don't include demonstrated responsibility as a prerequisite. The elements are identified in the Humana versus Western Heritage case, which is the defendant's a primary plan, the primary plan refused to pay or otherwise reimburse Medicare, and the plaintiff sustained damages.
But when you say the private plan refused to pay, that implicitly assumes coverage.
It's true, but Your Honor,
for example, what if the plan participant just was no longer covered? They left work, they left employment, there was no COBRA coverage or anything that followed them, whatever time lag has lapsed. You wouldn't say that there was still a claim there, would you?
I would. The case law is clear. The MSP Act is not a super judgment enforcement mechanism, which is what it would be in that type of scenario.
So you're saying there's a private cause of action when there is literally no question that that person is no longer covered?
I think there is in the private cause of action that you can bring, which is ripe when a primary insurer says no, that claim can be brought. Now they can defend that claim using a case within the case type of idea and avoid those damages. But the damages are there to be had to the extent that the coverage ultimately is theirs to be handled. Now, take a PIP case, for example. This is a cause of action that a provider could bring against a no-fault insurer in the same lawsuit.
So before you get to that, so within the context of this case, if there is a determination that the person was not an employee, that is a full defense to your case, correct?
Yes.
Okay. And so then we get to the next question of, okay, when does, was the magistrate's finding entitled to res judicata effect in this court?
And I believe that it was. I think the cases we cite make that pretty clear for purposes of, what that decision did was it resolved the issue of whether defendant is a primary plan. They are now by virtue of collateral.
Let's assume we uphold all of that. And then 3 months after we render our decision, the appellate commission reverses. How do we undo that mess?
Well, I would say, Your Honor, there's a procedural mechanism certainly for Conifer to seek motion for relief from judgment if they want that. The fact that there are these parallel cases is, complex, but not wrong.
But I mean, you certainly have to agree that you don't have a final determination of the workers' comp claim, right? I mean, it's been briefed. It's sitting awaiting a decision from a higher body, right?
I agree it's been appealed. That is true. I agree that for purposes of deciding element number one in our cause of action, which is what the trial court did, it was appropriate for collateral estoppel to be used to resolve that element, which is why it was appropriate to render C-10 the way he did.
But to Judge Yates' position, it does seem problematic that if we agree with you, our opinion comes out in a couple weeks, and then 3 months after that, the appeals commission comes out and says, actually, this person was not an employee. There was not competent material and substantial evidence supporting the magistrate's position. I mean, that is difficult to swallow just from a overall fairness perspective.
Well, I grant you that that certainly is an inefficient situation, but it's one created by the separation between what the Comp Bureau can do in here and what this court can do in here.
So
It's a problem that can't be remedied, if I may. If
do they have to seek a relief from judgment?
I believe it would.
And what if it's 2 years from now? I mean, at some point, our judgments are always just going to be kind of at the whim of when a executive branch agency decides to make a decision.
I think that if Conifer wants that relief, it has to continue on these dual paths. Now, to be sure, this is a problem of Conifer's own making. I mean, they chose to deny benefits, work comp benefits to a person, understanding, because we gave them notice of that this person was a Medicare enrollee. And
Well,
so
but I mean, you have to say, to make that statement, you have to essentially assume that their argument that she was not an employee was a bad faith argument. I
wouldn't say it was bad faith, Your Honor. It was a defense that they chose to raise. They obviously did not succeed with it. I'm not suggesting it was bad faith. I don't believe bad faith, Your Honor, is the metric for whether these damages are awarded. It's simply whether they are ultimately determined to be a primary plan.
But it sounds to me as if you're saying the die has already been cast on the double damages and there's nothing they can do.
Your Honor, I guess.
Even if upon a decision from the magistrate, a day later, they paid in full, they're still out of luck. They get hit for double damages.
No, I would say that if they succeed in establishing at some point that the underlying merits that this court relied upon to decide they were a primary plan are legally or factually incorrect, they could.
But that wouldn't undermine the collateral estoppel ruling. If you're right, and the trial court appropriately applied collateral estoppel here, why would that be undermined by a subsequent decision that went in a different direction? Collateral estoppel attached at the time of the magistrate's decision. Anything after that? So what?
I guess I would submit that at that point, there would certainly be new facts and circumstances that a reviewing court could hear in terms of a motion for relief from judgment to revisit that.
But this all brings me back around to the point that I don't get here. I mean, all of this seems so terribly premature to me.
Well, again, I think it's premature in a case if this was a tortfeasor case where demonstrated responsibility has to be established first.
Right. Yeah.
That's not this case.
Right.
These cases can and are directed by our courts to be brought in a circumstance where you can use the MSP cause of action. Take, for example, a PIP case. I've tried to offer that as an example. In those cases, because the circuit court can hear them together, you might bring a PIP case and along with the PIP case, bring a secondary payer case. Now, if the underlying PIP case has a defense of, say, causation, the underlying injuries don't relate to the car accident. In that case, you will litigate the question of whether or not the causation is or is not there. And the determination of causation will then determine whether whether the defendant carrier is a primary plan or not a primary plan, at which point, if they are a primary plan and the conditional payment has been made as an antecedent to that, that means the damages are now not only what you get under the PIP statute, but also double damages under the MSPA.
So any good faith dispute on claim coverage, an insurer is taking a risk of not, if they decide to challenge it, they could get hit with double damages?
They are taking a risk when doing a claim denial that involves a Medicare enrollee where a conditional payment has been made. Yes.
And you think that's what Congress intended, to hit insurers who have good faith? I mean, I'm not talking about insurers who, cry fraudulent actions.
Sure.
But just a good faith question about coverage, possibly involving someone who doesn't appear to get a W-2 check anymore, whether they're an employee or not. The insurer now has to calculate that if they decide to dispute that good faith coverage claim and they lose, they're not going to get hit with just having to make the payment. They're going to get hit with double.
I think that's a risk. Yes.
And that's what Congress intended.
I think Congress intended to create a system that is designed to both deter those types of claim denials and to make Medicare whole. And the way to do that would be to incentivize folks to bring the claim so Medicare could be made whole because.
Isn't the best way to make Medicare whole though, is to give them a few weeks after there's a determination to actually pay on it? Because then Medicare gets 100 cents on the dollar.
I think that would be a way, but that would put the MSP cause of action as only a super judgment enforcement mechanism, which the case law says it is not. So that's really all I have unless the court has more questions.
I don't think so.
Thank you.
Thank you. Appreciate it.
Just have a couple points. Number one, if you read the Humana case that Bronson relies upon, one of the elements is the plan is responsible for reimbursement. Doesn't say not possibly responsible for reimbursement. And that's a key element. And I agree with you, Judge Yates, that, you know, if Bronson would have came to Conifer day after the incident or several months down the road after the medical expenses were incurred and said, you owe us double now. I don't think that's what Congress intended. And that's what I think Humana teaches. And in fact, CMS withdrew its lien after it communicated with Conifer's Work Comp Council and pointed out that in fact, Ms. Roach was a volunteer, not an employee. Her last paycheck was April. This incident occurred in June. So, and the course and scope issue, I think, has been briefed adequately. I won't get into it. But I think the whole double damages theory by Bronson is putting the cart before the horse. And I think the trial court did the same thing. And to your point, Judge H, or your question about jurisdiction, you know, I'm not sure how I could frame a lack of jurisdiction argument because, you know, the work comp matter was pending. This is separate and distinct.
Right. It's really a ripeness problem, I think.
Yeah, which
Which is a prudential doctrine. It's not a
which is
hard
why
bar.
we filed a motion for stay, at
Right,
least
I got it.
one, I think two. Any other questions?
No, thank you.
you.
Appreciate it. Appreciate the argument. The briefing was very well done on both sides and that makes our jobs, I would say, easier, but this is not an easy area of the law. So I think we're going to be reading more federal case law than we may necessarily want to, but we will be doing that. So appreciate it. Those two cases are submitted. Moving on to the 10th matter for this today, docket number 375-280 in re E.E. Giroux minor. Argument in that case was waived. That matter is submitted. And then the last matter for today, docket number 374-139, in re Woodbury Drayton minors. No oral argument was preserved in that case. And that matter is submitted as well. And I believe that completes the first day.